Hi, I'm Gordon Weichel, a litigation attorney with Venn Law Group. Today, I'm going to discuss how to plan for and handle the process of removing members or shareholders from a closely held business without their consent, or an involuntary removal. It's often said that separation in a closely held business is like a divorce, and that an operating agreement addressing involuntary removal is like a prenuptial agreement. There's some truth to that. Planning ahead can limit the scope of a conflict, but there are key ways in which removing a partner, member, or shareholder from a business differs from ending a marriage, and a business's operating agreement should lay out a roadmap with those plans in mind. First, most businesses want to continue operating after a partner's removal. Rather than simply dividing assets, the agreement should include measures to ensure a smooth transition and align the incentives of the business and the departing member to encourage the member to support the business until they're compensated. Second, there are often 3 or more people involved in the decision, which brings majority voting into play, and with it the potential for the departing party to feel outnumbered or conspired against. The agreement should require transparency in the decision-making process and the financial decisions that follow. Third, valuing the departing party's interest is often subjective. The valuation process can be costly and contentious and may consume much of what's in dispute. To address these issues, it's helpful to draft your operating agreement with likely disputes in mind. In chronological order, the main questions to be answered are: what triggered the removal, and was that trigger valid? When is the valuation date, and what happens if the company value changes between that date and the buyout? Who pays for the buyout and gets the shares, and under what terms? Each of these should be addressed as clearly as possible to minimize disputes, especially since tensions may be high when these provisions are triggered. A good starting point for defining an exit trigger is to agree on a mix of clear rules and flexible guidelines. These rules could include defined events like a felony conviction, bankruptcy, or legal guardianship. The guidelines might include things like a majority vote by members or owners, still clearly defined, but subject to the judgment of the members. Valuation is tricky, so consider 2 common options. One is to have each party select an appraiser with set methodology and data valuation, and with the average of the parties' 2 appraisals used, or a mutually agreed upon third appraisal as the final arbiter. A second option for a 50-50 company is to include a clause where one party sets a price and the other can either buy or sell at that price. Finally, your agreement should spell out buyout terms, such as: can the buyout be financed, and at what rate? Is there security for repayment? Will the departing party retain any role or access to information as long as they are owed money? These details, when agreed upon in advance, can make transitions much smoother. Like any relationship, business partnerships evolve. That's why I recommend reviewing your involuntary removal provisions with your attorney periodically, before you need to use them. To learn more about how we can help, visit venlawgroup.com.